But I'm going to give you some information today about the judicial system. I find that there's a lot of confusion about it, and I blame it on about 60 years of TV crime dramas. Most of the TV crime shows, the detectives solve the crime, they arrest the defendant, and that's it. Everybody goes home. That's really the beginning of the judicial system. That's where it starts, is with the arrest. Everything else, it could go for 2 or 3 years after that, but the show's always ended there. So I've developed this speech to try to take out a lot of the mystery of the judicial system. So basically, there are 2 functions of the court. We resolve disputes and we interpret the law. And I use this example a lot that, when children have disputes, they'll go to a parent, or they'll go to a teacher, or they'll go to a coach, or they'll go to someone in authority over them who will resolve the dispute. But when adults have disputes, where do they go? They go to judges. Judges resolve the disputes between people in the same way that adults decide the disputes between children. We also interpret the law and deal with the details of the law. So, for example, in Texas, our murder statute says, quote, a person commits murder if he intentionally or knowingly causes the death of an individual. That's pretty straightforward. If you intentionally or knowingly cause the death of an individual, you've committed murder. Well, what about self-defense? What about the defense of others? What's an individual? So there are all kinds of details in that very simple, straightforward statute that have to be resolved. A person can shoot and kill someone, but if they did it because that other person was going to shoot and kill them, it's self-defense. They intentionally or knowingly cause the death of an individual, but the law says you're justified in doing that because it's self-defense. So who decides whether that's self-defense or it was murder and now the only other witness is dead? The jury. Juries decide those questions. The juries decide the gaps, and the courts decide the gaps and figure out the details of the laws. There are 2 types of courts: trial courts and appellate courts. And the best way I know to explain the difference is this. If you think of a trial judge as a referee on the football field or the baseball field, he's there in real time in the middle of the action. The appellate courts are like the referees in the replay booth. They look and see that the referee on the field make the correct call. And so that's generally the difference between an appellate court and a trial court. Rather than in a football game, the replay official will go look at the tape recording of the play and make the decision at the time of the decision. It's a little bit different in an appellate court. We wait till after the game's over. We look at the entire game film. The lawyers get an opportunity to point out specific plays during the game that they feel like the referee got the call wrong. And we look at it and we write an opinion. And if we say that they are correct, the referee made the incorrect call on the field, then you got to go play the game all over. We send it back and say, go try again. So it is different in that respect, but that's generally the difference between a trial judge and an appellate judge. As Jennifer mentioned, there are 2 kinds of cases. There are civil cases and criminal cases. And civil cases are disputes between individuals, or disputes between companies, or disputes between individuals and companies. They're private individuals rather than the government. Family law, real estate law, tax disputes, lawsuits, arguments over money, property, children, or injuries, those are civil cases. Criminal cases, punishment for bad behavior. Very straightforward. Felonies go, if you get convicted of a felony, you go to prison. If you are convicted of a misdemeanor, you go to the county jail. Non-serious offenders get probation. That's kind of the way the criminal system works. There are 2 types of legal systems. There are state courts and federal courts. Now, they teach an entire course in law school on federal court jurisdiction. It can be one of the more complicated areas of the law, but I try to generally boil it down like this. When you think of federal courts, think of the NFL. They got 30 teams. They're all equally funded. They all have the same kind of setup, the same number of coaches, the same number of players. The rules are identical. If you go to an NFL game in Jacksonville or an NFL game in Los Angeles, you're going to see the same game, the same rules. It's exactly the same. Those are federal courts. They're in the United States, and every state has federal courts within it. And they're all over, but they're playing. There's a small number of them, have a lot of money, a lot of resources. The federal rules are the same, whether you're in federal court in Florida or you're in federal court in California, the federal rules are the same. State courts are like NCAA. You might have really big schools, University of Texas with 70,000 students. You might have little bitty schools like TCU, where I went, with 10,000 students. You might have state schools, private schools. You might have Division I schools, Division III schools. They're all different sizes, all different shapes, all have different funding. Some are rural, some are urban. They're very different, but if you go watch a football game at any of them, the football game is going to be very similar. It's still going to be the same game. So state courts, every state has its own courts. If you go into the state of Arkansas and watch a trial, and you go into the state of Texas and watch a trial, it's going to look very similar. There might be some nuances in the law that are different that the lawyers, you need to know if you practice law in one state over the other. But for the most part, the procedure is going to look the same. It's the same kind of football game. But that's the difference between federal courts and state courts. Now, one of the things I find that people are really mystified about is what is the power that judges have. What can judges actually do? And I think there's a lot of people have the perception that judges are just put on the bench to do what they think is right. Just make the right ruling, make a fair ruling. You want somebody that's going to be fair and it's going to be right. Well, it's a little bit more complicated than that. What judges do is they listen to the arguments of the parties. So one lawyer on behalf of their client will say, Judge, under these facts, the law requires you to do X. And the other lawyer will say, under these facts, the law requires you to do Y. And we have this big debate over what is it that the law actually requires the judge to do. So the judge's job is not so much to do what they subjectively think is the right ruling. Their job is to objectively apply the correct law and apply the law correctly. Now, I mentioned the murder statute previously, how you can have differences of opinion and details about how things work. Well, that's the situation you find yourself in. We may agree what the facts are. We may agree that this is the law that applies, but what's the interpretation of that law? So there are times when the courts have to fill in the gaps of the law. And the best example I know to do this is in the 1950s, there was a game in the Cotton Bowl. And one of the teams kicks off to the other one, and the receiver gets the ball and he's running down the sideline and he's about to score a touchdown. And one of the players on the bench runs off the bench and tackles. And so the referees all huddle together and go, well, what do we do with this? I mean, there's no rule in the book that specifically applies to that situation. Who could have ever conceived of someone running off the bench and tackling a guy while he's about to score a touchdown? Well, there's technically a rule that would apply. Too many men on the field. And, that would be a 5 to 10 yard penalty, depending on that would reward misconduct. I mean, the guy was going to score a touchdown. And so a strict application of the rule in that situation just wouldn't fit the circumstances. So the referees huddled together and decided the thing we need to do is award the touchdown. He would have scored anyway, and we're not going to reward bad conduct. So they awarded him a touchdown. Well, that's the gap filling authority that the courts have. When we deal with situations that the law really hasn't contemplated, and there's just not a specific rule that applies, at that point, the courts will say, this is what we believe, based on the history, the intent of the law, this is what we believe the law ought to be, and they'll make that ruling, and that is what's called the common law. when the judges fill in those gaps between the written law that the legislature passes, which is statutory law, when the judges fill in those gaps, that gap filling is called the common law. Now, of course, the legislature has the authority to come back later and say, well, we don't really like that rule. We're going to make a different rule. Okay, fine. It'll be addressed the next time that happens. But they may say, you know, that rule is perfectly fine. We'll just leave it as it is. And that becomes the rule for cases from there forward. So that kind of gets us into the question of the differences between the roles of judges and juries. Now, the best way I know to explain that is to go back to the football example. Judges decide legal issues, juries decide fact issues. So what's a legal issue? Well, the judge would be the referee on the field, and he would decide the penalty. You know, does it violate a rule in the rule book? The jury would decide the fact question. Did they make a first down? Did they cross the goal line? You know, were they inbounds or out of bounds? So the judges are making the rule decisions, and the juries are making the fact decisions. They're the ones that are deciding, you know, what actually happened here. So that it's a partnership. So it's kind of a dance that the court and the jury, that the judge and the jury operate together. And the judge will give them the law and the jury charge, and the jury will find the facts, and the judge and the court's charge will tell them, if you find this, then you find that, because that's what the law requires. So that's what juries do. Juries listen to the facts, listen to the evidence, and decide what they believe is the correct version of the facts. As a result of that, there's a difference in standard of reviews that are applied by an appellate court. So if appellate court's reviewing what a judge did, they're going to look at it what we call de novo. I mean, we're going to look at it all over again as if the judge never made a ruling. We're just going to decide what would we do in that situation, and if what they did disagrees with what we did, then they were wrong. Fact questions are decided based on a clearly erroneous abuse of discretion standard. I mean, basically, if there's any evidence that supports what the jury does, then it gets affirmed. So the appellate courts are very deferential to the roles of juries. The jury decisions, if all you have at the end of a trial to appeal is the jury's decision, you don't have anything to appeal. What you've got to appeal are things that the trial judge did. You've got to appeal the trial judge's rulings, because you're going to go nowhere trying to appeal with the jury made the wrong decision. There's just too much deferential rule. So we think in terms of the state courts and the federal courts, and to a large extent the federal courts. As I mentioned, there's a huge course of federal jurisdiction, but basically they handle matters that transcend state lines, across state lines. That they're nationwide issues. That's what federal law applies. State courts apply the rules that apply within the boundaries of our state. So, for example, if someone commits a crime with a gun, it's typically a state court crime. If they commit a crime with a computer, it's typically a federal court crime. The federal courts are judging the issues that transcend the state lines. Now, one exception to that would be there are areas that are federal jurisdiction, and if you've committed a crime within the boundaries of those areas, even if you use the gun, you're going to be charged in federal court because it's on federal property. So if you commit an offense on the Red River Army Depot within the boundaries of the fence, you're going to be charged in federal court. But if you go outside the gate and commit it out there on Highway 82, you're going to be charged by the Bowie County District Attorney's Office, state court. So there are different kinds of appellate courts or state courts or federal appellate courts. Texas has 14 intermediate courts of appeals. I was on the 6th district court, which is here in Texarkana, but there are 14 across the state. And then we have the 2 high courts in Austin, the Texas Supreme Court that hears civil cases, and the Texas Court of Criminal Appeals that hears criminal cases. In the federal courts, you have Federal Circuit, they're intermediate courts. There are about 13 of those, although there are a couple others that aren't numbered, that military courts of appeals and and courts like that. But there are about probably 13 or 14 of those across the United States that hear the appeal from the federal courts, and ultimately the United States Supreme Court hears the appeal from those. Now, you can get a case from a state court that ends up in the United States Supreme Court if it involves a question of federal constitutional rights or federal statutory rights. However, I will point out that the United States Supreme Court hears about 80 or 90 cases a year. I had 2,700 on my docket when I was a district judge. I was one of about 1,000 judges in the state of Texas. There are 50 states. You can just do the math and imagine they hear very few cases. I think the only case that I know of, there's only been one from Texarkana that ever ended up in the United States Supreme Court, and that was about 40 years ago. So that really kind of gives you an idea about the court system and how the courts apply. Now, I wanted to talk a little bit, transition a little bit about the Constitution, how the Constitution kind of figures into this system. Back early in the history of the United States Supreme Court, they decided the case Marbury versus Madison, and they adopted the idea of judicial review. And basically what the Supreme Court said is that, well, the Constitution places limits on the federal government. And if we're not able to say whether a congressional statute violates that Constitution, then the Constitution is worth nothing. I mean, if they could just, they could pass a law the next day saying we have an official religion. Well, the First Amendment specifically prohibits having an official religion. And so the Supreme Court said it's implied from the Constitution by the separation of powers, by the three branches of government, it's implied that we, the Supreme Court, have the authority to declare something to be unconstitutional. They don't have the authority to do that. And so that started this concept of judicial review, which, interestingly, there are people today that question whether judicial review is valid because there's nothing specifically in the Constitution that says it. But the Supreme Court reasoned through the process and said it just doesn't make any sense. The Constitution would be worthless if we're not able to interpret whether laws have violated. The scope of judicial review has changed over the last 200 years. When it originally adopted, they looked at it from a perspective of, did the congressional law go too far? Did they exceed the authority that they had under the Constitution? Now, and this was a result of a lot of the civil rights cases, now judicial review includes also, well, has the state not gone far enough? Have they not done enough to comply with the constitutional provisions? And the transition was made before it was made. The very limited, did they go too far philosophy led to a lot of horrible decisions. Decisions that allowed the forced relocation of Indians, the decisions that allowed slavery, the decisions that allowed the internment of Japanese citizens, because they were looking at it from a, well, they didn't go too far. But now they look at it and say, wait, you've got an obligation to affirmatively provide the constitutional rights of people. And it's not enough to just say that you just went out and overtly violated it. So that's kind of where we are in judicial review today. They look at it not only did you exceed your authority on the Constitution, but have you done enough to make sure that you've complied with the requirements of the Constitution? But it's interesting because people have in their own minds about the Supreme Court philosophy. You got liberal, you got conservative, them liberal judges, or look at them conservative judges, look what they're doing to us, well, it's really a little more nuanced than that, because you have liberal and conservative, but you also have maximalists and minimalists. And so a maximalist, strict constructionist would be one that would say, well, the Constitution says you can have an army and you can have a navy. It doesn't say anything about a Marine Corps. It doesn't say anything about the United States Air Force. So therefore, there's no authority for a Marine Corps or an Air Force. Well, a minimalist strict constructionist would say, well, okay, yeah, okay, yes, it doesn't say anything about a Marine Corps, but every Navy in the world at the time they wrote the Constitution had a Marine Corps. So it's implied that when they said Navy, they meant also Marine Corps. And then they would say, you know, well, armies are they're these organizations that, you know, kill people and break things. And you know, now that we've developed airplanes to do that more efficiently, it will just, you know, obviously it's implied that they have the authority to make an air force. And so you have these different philosophies there. The minimalist liberal constructionists might say, well, the founding fathers listed an Army and Navy, but if modern technology comes up with something new and is consistent with modern thought, then we'll go for it. They could never conceive of airplanes, but they, you know, certainly intended this not to be defenseless. The maximalist liberal constructionists would say, do whatever you want to, as long as you get 5 judges to approve it on the Supreme Court. So there are different philosophies even within the division between conservative and liberal. And that's one of the things that will come up a lot of times in opinions. Not to get too much into the weeds of the different opinions, but I think you most recently saw that in this Dobbs opinion, where you had the Chief Justice Roberts trying to cobble a construction that would say, we're not doing away with the right of abortion. We're saying it's, you know, that we're saying that the Mississippi statute at hand limited it to 15 weeks is consistent with Roe versus Wade, which said you could have it up till the first trimester. And so he was trying to, you know, work together. There were all these negotiating factors trying to bargain for the position to avoid the extremes. So that's how that dynamic works. Is you might have these different factions, but they're minimalists or maximalists, and they're trying to work with one another. So that basically tells you how the court structure works. That gives you a little smidgen of understanding about how the Constitution plays within the court system. Now I want to talk about the relationship between the federal government and the states. Originally, when the Constitution was drafted, the 10th Amendment says, you know, all powers not delegated to the federal government in the Constitution are reserved to the states and to the people. So it was clear. If the Constitution doesn't say Congress can do it, then they can't. That power belongs to the state. Well, that was modified. The 14th Amendment that was passed after the Civil War says, no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And so now you have to interpret the 10th Amendment in light of the 14th Amendment. And so what has effectively happened is that the Supreme Court has what they call selectively incorporated, but they have basically applied the first 8 amendments to the state governments. So state courts, state laws are now bound by the first 8 amendments through the 14th Amendment. Now, if you look at the First Amendment, it says Congress shall make no law respecting the, you know, freedom of speech, freedom of religion, freedom of association, freedom of petition government. Congress shall make no law. But the way it's been interpreted now in light of the 14th Amendment is, well, Congress also means state legislatures. It means state courts. It applies, even though the language specifically says Congress, the 14th Amendment applies. So we have the dynamic between the 10th Amendment, separation of the powers of the states from the powers of the federal government, and you see the 14th Amendment that's modified that. And that, in my opinion, is where much of the debate within this country today exists, is in trying to interpret the 10th Amendment in light of the 14th Amendment. When is it a state issue? When is it a federal issue? When is the federal government going too far? When the state's going too far? That to me is an explanation for why there's a lot of discord, is that dynamic. I do want to talk a bit about the 7th Amendment, because that's the amendment that Bowden looks at. And Jennifer mentioned that the 6th Amendment deals with the right of jury trials in criminal cases, and the 7th Amendment deals with the right of jury trials in civil cases. But the 7th Amendment has language in it that's not in the 6th Amendment that puts a limit on the court's abilities to review cases. The 7th Amendment says that no fact tried by a jury shall be otherwise re-examined by any court of the United States than according to the rules of common law. So basically what that means is that when an appellate court or a district court, when the jury's made a ruling, they really can't re-examine it. The jury just pretty much has the authority to decide that question. Juries have a lot more power in civil cases than they would in criminal cases. In criminal cases, the appellate court should be able to look at every fact question that the jury decides and decide, did they make the right decision? But in civil cases, not so much. They're limited in their review. Well, why is that? Well, there are suits between individuals, or suits between private people. The government's not involved. If the government's involved through the executive branch, the prosecutor being part of the executive branch, then you got to have another branch watching the government. You got to have the judicial branch looking over the government shoulder, acting as its executive branch, and make sure it's not overreaching. So when the federal government charges someone with a crime, the federal judge there's a dynamic there. They're looking over their shoulder and making sure that this branch of government has not exceeded its authority. So in Sixth Amendment cases, there's no limitation on what the appellate courts can review in a criminal case. But in a civil case between private individuals, the role of the government is just limited to, we're just the referee. We don't have a dog in a fight. We're just here to make sure that the ruling gets made. So in those instances, the courts don't apply as much rule to the cases. They let the jury's decision stand. One of the things, and I'll finish with this, is that in my experience during my 20 years as a judge, 12 as a district judge, and 8 on the Court of Appeals, I tried probably there were at least 170 jury trials as a judge. I think I tried another 30 as a lawyer. I think I reviewed probably another 100 as an appellate judge. One of the things that's very amazing to me is how consistent juries are in their rulings. I used to keep up with, have a list of all the jury trials I ever tried, and I kept up with the verdicts to try to make sure that if I ever had to decide one, if they ever came to me instead of a jury, that I would be consistent with what juries are doing. It was very amazing to me how consistent juries are. Juries speak for the community. We bring in 12 citizens that don't have any issue, and they listen to all the evidence and they make their ruling and they go their way. And I don't think they realize how consistent they're being with the other juries that are coming in and listening to cases and making rulings. So I do want to finish with that. The Seventh Amendment is an extraordinarily important amendment in our country because of the role that jurors have, that individuals have. We don't have government bureaucrats that are deciding these issues. We don't have government agents. We don't have the king's henchmen that are deciding these issues. We have individuals from every walk of life that come in and decide cases. So basically, that is a primer on the court system in America, and I'm hopeful I've been helpful to you in that. Does anyone have any questions about any of that? Yes, sir. Sponsor. Okay. Okay. I have a list of about 4 or 5 that keep me up at night over all the years. Yes, sir. Those are cases where I felt like factors other than the law and the facts made their way into the decision. So yes, those do bother me still. Yes, sir. Well, I'll quote Judge Fisher, who was a longtime federal judge in the Eastern District of Texas. He said, "Often reversed, but never wrong." Judges always take the position that, yeah, if I made the decision, it's the right decision. I always approach the case with the understanding that I'm human and it is possible to make the wrong decision. And so I always approached it with that cautious thought in my head. don't get blinders. Listen to what they're telling you. Make sure you understand what's going on. But the only way I knew to do it was to let the parties present their evidence, get the jury involved, make sure I was really listening to what they're saying, that I wasn't missing something, overlooking something, and then applying the law with the facts and letting the system work itself through. And that's all I know to do, is just to let it work itself through and trust in the system. And hopefully to minimize those issues. But yes, it is a staggering responsibility when you're deciding cases. I used to keep on my bench, there's a passage, Matthew 7:2 says, for in the same way you judge others, you will be judged, and the measure you use will be measured against you. Well, that's pretty sobering when you're in a judging business. So I used to always keep that on my bench up there. It's not that we want to reach a particular result, but it's just you want to make sure you're listening, make sure you're understanding what the arguments are. So yes, it does. Have been 4 or 5 cases that still bother me today. Anyone else? Yes.
You ever feel like advice for one side or the other?
Excellent question. So when you've heard something 1,000 times, when you've heard the same kind of case 1,000 times, and you know in advance what the law is, how do you be fair? Well, the way you're fair is you remain willing to be convinced that this time it's different. Tell me how it's different. I go into it, I've listened to it, I know what the law is. I've heard this 100 times before. Tell me why this case is different. So that's how you approach to be fair, not be biased. Anything else? Yes, ma'am.
Personal question. With the coach, that you can have from the chaplain's way and the law. I just didn't see it going that way.
You talking about the coach that was praying on the 50-yard line? I'm not real familiar with the facts of the case, other than what I've just read in news blurbs. The First Amendment is a very difficult amendment. If you ever do any study of First Amendment law, I mean, there are people who devote their whole careers to First Amendment law. It's because you have this dynamic. There should be no establishment of religion, but there shall be freedom of religion. So, there's always a conflict between those. When are you going too far? When and so all I can say is First Amendment questions are always very difficult. Very difficult. Yes.
What makes them go back and look at like Roe versus Wade and things like that? What makes them go back to something that has to happen to make bring it up?
Yes, the case has to be, Supreme Court hears what it wants to hear. You petition the Supreme Court and say, we ask you to hear this case, and they'll say yes 80 times out of 10,000 that are presented to them. What happened in that particular case is Mississippi passed a law that said that it absolutely prohibited abortions after 15 weeks. And so I believe it was Planned Parenthood in Mississippi challenged that law in federal court, said it's unconstitutional to Roe v. Wade. The Mississippi court upheld the law. The Fifth Circuit Court of Appeals in New Orleans upheld the law, and then it went to the United States Supreme Court, and they reversed it. And they upheld the law, but they also, in the same process, reversed Roe versus Wade. The Justice Roberts was of the opinion that we don't have to go all that way. We can just uphold the law. We don't necessarily have to reverse Roe versus Wade, but his position didn't win out, and they ended up reversing Roe versus Wade. So yeah, it has to be brought before they can decide. Anything else? Yes, ma'am. Mm-hmm.
What orders, presidential, governor,
Yeah.
be like laws, treated like laws.
Yeah. Yes, they are, and administrative regulations are there's a whole field of study in administrative. I mean, people devote their whole careers to administrative law, but the example I always give how administrative law works is when Congress adopted the Americans with Disability Act. in the early 90s. And the law says, in general terms, it says that any public building shall be accessible to anyone that's, physically limited. So, you have to have wheelchair ramps, you have to have, handicap bathrooms, you have to have all these things that the law requires. Well, Congress isn't going to sit there and figure out, well, what's the dimensions of a wheelchair ramp supposed to be? How many inches over, how much is the rise versus run over the, the length of it, and how big thick do the railings have to be, and, how big does the landing have to be? They're not going to sit there and worry about all that stuff. And so they give the authority to an administrative agency. The administrative agency will then draft regulations to fill in the gaps. And so you can challenge those regulations and say, well, they went too far. They didn't have this goes beyond merely filling in gaps. Now they're writing laws, and you can challenge those. But generally that's the way administrative regulations work. Anything else? All right. Well, thank you for the opportunity here today.